Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Aggravated domestic battery defense lawyer in Chicago, Illinois. An aggravated domestic battery charge in Chicago, Illinois can carry major consequences. Aggravated domestic battery is one of the most severe domestic violence charges under Illinois law, and a conviction can result in years in prison, plus several additional civil consequences. If you've been charged or arrested for aggravated domestic battery in Chicago, get in touch with the domestic violence lawyers at Combs Waterkotte. We'll review your case, build a legal defense strategy specific to your circumstances, and fight to minimize the impact of your aggravated domestic battery charges on your life, career, and reputation. Aggravated domestic battery lawyers serving Chicago, Illinois, and all of Cook County. Aggravated domestic battery cases, like any domestic violence cases in Chicago, Illinois, can get out of hand quickly. These charges can stem from misunderstandings, exaggerations, and, in some cases, outright lies. Individuals facing an aggravated domestic battery charge in Chicago need a trusted local lawyer to step in and assist as soon as possible. At Combs Waterkotte, we've defended hundreds of Chicago clients from domestic violence allegations in the past. When you take on our firm to handle your aggravated domestic battery allegations, we start with a free, confidential consultation to get your side of the story. From there, our expert team of attorneys, law clerks, and paralegals get to work scrutinizing every aspect of the prosecution's case, searching for inconsistencies and rights violations that can help to get your charges reduced or dismissed. Whether this is your first domestic violence charge or you've been convicted in the past, we treat each case with the same level of focus and dedication. If you're looking for an award-winning team of Chicago, Illinois-based lawyers to handle your aggravated domestic battery case, call us today at 314-900-HELP or fill out our form online. Don't wait, though. The sooner you hire an attorney, the better the chances are at receiving a favorable outcome in your case. What is aggravated domestic battery in Chicago, Illinois? To understand what constitutes an aggravated domestic battery charge in Chicago, Illinois, first, it's important to understand what a non-aggravated domestic battery charge is. According to 720 ILCS 5/12-3.2, domestic battery is defined as knowingly and without legal justification, causing bodily harm to a family or household member. Touching or acting toward a family or household member in a way meant to offend them or start a fight. Aggravated domestic battery is essentially a more severe version of domestic battery. Under 720 ILCS 5/12-3.3, a person commits aggravated domestic battery when, while committing domestic battery, they cause someone great bodily harm or permanent disfigurement or disability. Causing that level of physical damage isn't the only way to be charged with aggravated domestic battery, though. The statute also mentions that an individual can be charged with aggravated domestic battery when, while committing domestic battery, they strangle their victim. Is aggravated domestic battery a felony in Chicago, Illinois? In Chicago, Illinois, aggravated domestic battery is always charged as a felony offense. Specifically, aggravated domestic battery is a Class II felony charge. Class II felonies in Chicago come with significant prison sentences if someone is convicted. 3 to 7 years in prison. 7 to 14 years in prison for an extended term. While a Class II felony conviction may be subject to probation negotiations in some instances, aggravated domestic battery statute mentions that a person convicted of a second or subsequent aggravated domestic battery offense must serve out the entire 3 to 7 year prison sentence. The statute also mentions that, even for first-time convictions, a defendant found guilty of aggravated domestic battery must serve a mandatory minimum sentence of 60 days in jail. A conviction may also result in the loss of firearms rights under the Gun Control Act of 1968. Civil penalties for aggravated domestic battery in Chicago, Illinois. In addition to the criminal penalties for aggravated domestic battery outlined in the Illinois Criminal Code, aggravated domestic battery convictions in Chicago, Illinois also come with a potential litany of civil penalties. These civil penalties are outlined in the Illinois Domestic Violence Act of 1986. Some of the most common civil penalties that come with an aggravated domestic battery conviction in Chicago include orders of protection, the requirement to stay away from the victim's residence, school, or workplace, child custody issues and visitation requirements, counseling requirements, including domestic violence intervention programs, anger management training, substance abuse training, if applicable, financial support for children, if the alleged victim is your spouse with whom you have children, medical costs for injuries to the alleged victim, property damage done during the offense, criminal defense strategies against aggravated domestic battery in Chicago, Illinois. Given the serious nature of an aggravated domestic battery charge in Chicago, it's important to involve a criminal defense lawyer in your case as early as possible. An attorney can look closely at all the available evidence and undermine the prosecution's strategy. At Combs Waterkotte, we've achieved charge reductions and dismissals in Chicago aggravated domestic battery cases before. We've even managed to get clients not guilty verdicts at trial. Here are some of the criminal defense strategies we've found to be most effective in Chicago, Illinois domestic violence cases. Self-defense. In aggravated domestic battery cases in Chicago, self-defense is often a central strategy. It focuses on whether the accused used force to protect themselves from immediate harm. If the defendant reasonably believed they were facing serious injury, their actions may be legally justified. A defense attorney can present medical records, witness accounts, or prior incidents to support this claim. Lack of intent. Aggravated domestic battery charges in Chicago, Illinois typically require proof that the defendant acted knowingly. A lack of intent defense argues that the injuries were not the result of deliberate conduct. Instead, the incident may have been accidental, misinterpreted, or the result of a chaotic situation. By focusing on inconsistencies in the evidence or unclear circumstances, a defense attorney can raise doubt about intent. Miranda rights violations. Police must inform a suspect of their Miranda rights before any questioning. If officers fail to do so, any statements made may be excluded from court. In an aggravated domestic battery case, suppressing this evidence can significantly damage the prosecution's case and limit their ability to prove the allegations. Fourth Amendment violations. The Fourth Amendment limits how law enforcement can search property and collect evidence. In a Chicago, Illinois aggravated domestic battery case, officers may respond quickly and enter homes or seize items without fully complying with legal requirements. If a defense attorney can show that police lacked a warrant or probable cause, critical evidence may be thrown out, weakening the case against the defendant. Duress. A duress defense may apply when the accused engaged in conduct because they were threatened with immediate harm. In high-conflict domestic situations, a person may act out of fear. If the defense can demonstrate that the defendant faced serious threats and had no reasonable opportunity to escape, it may reduce or eliminate criminal responsibility by showing the conduct was not truly voluntary. Fifth Amendment protections. The Fifth Amendment ensures that individuals cannot be forced to incriminate themselves. In aggravated domestic battery cases in Chicago, statements obtained through coercive questioning, intimidation, or without proper safeguards can be challenged. A defense attorney may seek to exclude these statements from evidence, making it more difficult for prosecutors to establish guilt. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.